So welcome to this 7th webinar. Some housekeeping rules. We will have a discussion at the end after all 4 speakers. But in the meantime, you can use the Q&A box to type any questions during the presentations, the chat box. And if there are any really burning issues, please raise your hand, but otherwise we'll keep the questions till the end. The session is being recorded, and by remaining in the meeting, you are consenting to it being recorded. Why doesn't my page down work now? Any ideas? Can't move to the next slide.
I think you need to click in your presentation.
Thank you. Thanks. Okay, this is a webinar in the ENRIITC project series. ENRIITC is a project led by the European Spallation Source with 5 RIs and 5 industry liaison officer organizations. It's a consortium, and it aims to build a permanent pan-European network of ILOs and ICOs, and to enable industry to become a full partner to utilize research infrastructures in various roles. The Enrich Your Knowledge series, of which this webinar is one, is a series of online training and organizational webinars targeted to experts involved in setting up collaborations between RIs and industry. And the overall aim is to share knowledge, expertise, skills, and best practices amongst ILOs and ICOs. At the end, I will discuss the last webinar in this series. This slide will come back again, and we'll discuss so that you can save the date and what we would like to invite you to be involved in that webinar. The webinar this afternoon will explore various issues which can arise in setting up industrial RI collaborations and draw lessons from the very varied experience of the speakers and participants. And I won't go through all these things, but these are various points among the various points which will be dealt with. We have 4 speakers, and I will introduce them now to you, and this is the sequence in which they will be talking to you. We have a very full program, so it's going to be quite a housekeeping issue to get through everything on time and hopefully have time for a discussion at the end. Our first speaker will be Laura MacDonald, who is Chief Executive of the Association of European Science and Technology Transfer Professionals, ASTP. I won't go through all these bio sketches in detail. You will get the slides later on, and then you can see, but you can see here that Laura, before she was heading up ASTP, has a history of technology transfer offices in the UK and in the Netherlands. And she spent 10 years at Leiden University in that function before her current position. She's also involved in the Licensing Executive Society and Autumn. Martin de Kort is Senior Scientific Program Manager at EATRIS, and he's very much involved in setting up bilateral and multilateral public-private collaborations and infrastructure development projects. In that regard, he's involved in matchmaking and hubs with SME and big pharma and academic users. He's had 10 years before coming to EATRIS of pharma R&D experience, including Organon, Schering-Blau, and Merck. And in that capacity, he was involved in discovery and patenting. Then Tamara Carapina will look at the legal side. She's Senior Legal Counsel for EATRIS, studied law and specialized in European Union law, IP law, and contracts and privacy law. Worked in public and corporate sector, including for the Croatian Ministry of Foreign Affairs and European Integrations. Before joining EATRIS, and she was working in a fast expanding pharmaceutical company as head of legal and IP department. So she brings to the table industrial, but also European organizational experience. And finally, our fourth speaker, Victor Saez, head of the market analysis group at Fusion for Energy. He's a lawyer specialized in intellectual property, had 14 years at the European Commission before joining Fusion for Energy, F4E, which he joined in 2008, and he's currently group leader of the market analysis group, responsible for pre-procurement activities, supply relationship management, market analysis, IP, and tech transfer. Those are our four speakers. This I will come to later. So without further ado, I would like to introduce the first speaker, and that is Laura MacDonald, and I'll stop sharing the screen now. Laura.
Thank you very much, Nigel. Thank you, EATRIS, of course, for inviting me to join this exciting session. I'm hoping I'm going to be sharing my screen properly, so let me just see, is that just a quick nod? Nigel, I presume everything's working okay? You can see my screen, great, okay. So as Nigel said, we do have kind of a packed program of information to share, but I must say I am very much looking forward to the discussion session at the end. So what I've done, and obviously in discussion with the other three speakers, is we're all going to approach the topic, obviously with our experience and slightly different perspectives. So we hopefully aren't going to be overlapping. And so my take on this afternoon's discussion and my contribution is very much going to be around my experience and sharing the experiences of the challenges and the things to think about when setting up collaborations, where on the one hand, you've got a culture of a research science-based organization, and on the other, you've got a corporate industry-based organization. And whether we're talking bilateral or whether we're talking increasingly, of course, and nowadays, everything seems to operate with consortia. I have examples of both, and basically what I'm going to do is I have about a dozen slides. There is a story behind every single line. I will not be telling you all the stories, but if there's something that I don't go into in any detail that you want to hear more about, then absolutely please feel free to hang on to that point and flag it in the question afterwards. And of course, you know, I'm very happy to be connected to the EATRIS community, so ASTP is really happy to support it. So we're also available not just this afternoon, of course, but later on as well. So without further ado, I don't want to, well, okay, I'll start with the disclaimer. I'm not going to be naming any names. I'm not going to be shaming any organizations. And a lot of the examples and perspectives that I've tried to pull together for us all this afternoon might leave you at 15 minutes with a suggestion that the world is a difficult place and that things go wrong more often than they go right. That's absolutely not the case. I really had to trawl my decades of experience to give enough examples to illustrate things to think about, just simply to make sure that, if possible, you and we in the future can avoid problems arising. So that's really what the focus is all about. So this is not a typical summary of academic industrial relations or research centre relations in a nutshell. So it's a little bit how not to manage deals, or as my perspective maybe tells me, it could only happen to me. Some of the things were quite unexpected, and even with all the best planning in the world, things obviously change, and it's very much about how you then manage these relationships, hopefully, that you've built up. So not everything rests in what's in the legal contract. So I'm going to talk about the sort of three phases of the relationship building, so very much about that perspective. So just some examples of things that could, or indeed have in my case, perhaps gone wrong, in the setting, the scene, getting ready to build a relationship. Secondly, what can and does happen sometimes as you move into the, let's call it the formal negotiation process. So you're actually trying to pin down and structure two things simultaneously, of course. It is a deal. It is, whether it's a research collaboration or an exchange of know-how and materials, or a fully fledged license deal perhaps around really exciting new innovation, and you're collaborating to transfer, you know, rights to commercially use early stage technologies, maybe patents and intellectual property as well. So whatever kind of collaboration you're setting up, then some of these points might happen. So this is just flagging up what might happen in the negotiation process. And again, once we've actually got the deal done, and I think several of us seem to have legal training on our CVs that Nigel shared, and I'm certainly one of those people. And while there's a temptation to sit back and relax and go right over to the technical people, over to the scientists, over to the commercial people to live with the deal, that quite often actually what's happened in the contract, or what the words that have been used in the contract, or the circumstances around people's understanding of what was intended and what was actually then written up and what we're then living with afterwards, don't always match up and stay facing the same direction. So I've got some examples there of things to think about or look out or avoid once you have signed the deal and you're living with the deal. And then I have just attempted to summarize some perspectives on one or two slides at the very end. So hopefully some of this might resonate with some of you. I look forward to hearing whether I am alone. In fact, it really could only have happened to me, or if in fact some of these issues really are things that you have thought about or experienced. So let's press on. So setting the scene, this is getting ready to enter your relationship. And of course, for many of you or us, we are entering repeat relationships, repeat deals with parties that we know already, either because our scientists have been collaborating for years, or as institutions we are known to one another. However, I think increasingly we are also increasingly likely to be engaging, and I know one of the objectives of ENRIITC is to really literally enrich the diversity, breadth and depth of relationships between the research centres and infrastructures on the one hand and the industrial sector on the other. And so therefore we're very likely to be dealing increasingly with people that we don't know, with organisations, either as organisations, companies we've never met before, or organisations who are new to this combination of commercial and non-commercial partners working together. So quick 3 flags to think about there, or 4 flags really. The right opposition. Opposition is an emotional word, and I don't fully mean it in a negative sense, but for sure there will be people on the other side of the table, literally, that you need to understand and think about in advance. Both who are you with and what is you, so it's identifying the roles, mandates and responsibilities. And I'm sure, sometimes find ourselves in a situation either because it's a known partner, perhaps increasingly because we are all strangers to one another. It's not unreasonable to make sure you know whether the people that are actually fronting the discussion, making suggestions, proposals, building up the picture, because of course you have a combination of presumably a little scientific element of describing what's involved, whether it's equipment or the plan for development or whatever. You've got, certainly there'll be a commercial angle to, is there pricing, is there money, is there, what's the future looking like? And then of course you've got the legal, let's capture everything in documents which are going to record our commitments and obligations and rights. So you need legal, technical and commercial input, and the same on the other side. So are you clear that whoever you deal with is in fact authorized to sign off a deal? And one quick line, maybe this has happened to some of you. You spend quite some time, it can even be months, negotiating what looks like a lovely deal, and then it turns out that actually you think you've concluded things, and the other side that you've been dealing with for months are very happy, only for them to come back and say, okay, so now that we've got all this finalized, we now need to refer it to our board, or we've now been taken over and we're referring this to our US-based Californian legal advisors and so on. In other words, are they able to do the deal, and can we sign off on it? Also a question about to travel or not to travel, just to think about, and I use the word travel, and even post-COVID, when we are starting to travel again, at some point in the relationship, it's good to think about when and if a face-to-face engagement is useful. Is that during negotiation? Is it at the very beginning to get to know each other? Or is it to showcase the technology infrastructure that you are going to be making available and working on with them, etc. So thinking about the balancing act between digital engagement and emailing to structure a relationship and a deal versus actually at some point in the whole story meeting each other. And then the final thing is, on the one hand, you may be very clear on your side of the table that either you and your colleagues together can fully understand and describe how, I'm calling the word technology, but basically the technical aspect of the relationship might look like. Again, it could be interesting to work out and make sure that the people on the other side fully understand what's going on. So you may find some of the planning is very much around establishing some base understanding that you are using the same terminology, that you do actually mean the same things when you're talking on the technology front. And just because people have a responsibility or a role in an organization which is in the technical area, it's never a bad idea to make sure that you really are talking about the same technologies or the same use and applications of technology. And again, some interesting stories of where that's not always worked out. Again, during the negotiation phase, we've also got the idea or the reality that there can be, and I call them political, I should really have a small rather than a capital letter P, but political factors. And again, that's to do with you understanding who you're representing and what the drivers are for shaping what the end of the relationship terms and conditions will look like. Are you balancing institutional goals and objectives? Are you under regional pressure to do more deals with local companies or give preference even to local immediate neighbours? Is there a balance between, you know, wanting to be able to maintain, I'm calling it an academic, but a real scientific integrity to the focus of a project, where the other side might be willing to say, listen, let's evaluate where it's going, and after 6 months or 12 months or every 6 months maybe have the right to stop the project, which is clearly not in a pure academic driven environment an attractive way forward. And so just balancing, you know, what are the different drivers and how important these things are is also important to understand at the start. And the other aspect, which it can also vary, not just from organization to organization, but from region to region. Are there any challenges that you should be aware of that might arise from the existence or otherwise, or perceived existence of conflicts of interest? Again, to do with the key people and organizations involved in the relationship. So you just need to be aware of all of that before you move forward. And then here are some I have very short descriptions here, but in terms of styles of entering into relationships during collaborations, I would just like to spend a minute or two running through these particular scenarios. And again, some of them may be familiar. The take it or leave it scenario, and that's very often the case where you have larger companies or even established research centres who are in the business of, you know, a lot of material transfer agreements. They are doing a lot of software access licenses. They are doing quite a number of small-scale collaborative projects, and with lots of different organisations. And so they've developed, let's call it a model agreement, model terms and conditions that they offer, and they actually do expect a take it or leave it response. And sometimes that is absolutely fine, and sometimes it's impossible for a very, very good reason. It might be impossible for you to either accept or enforce somebody else accepting your terms and conditions. And one of the lessons that I learned was that, especially dealing with larger companies, they just don't have the time or resource to negotiate. In other words, they probably like you to think that they would walk away rather than have to unpack their so-called standard terms and conditions of engagement. And so one of the challenges there that I have found has been not so much what you might wish to or need to negotiate or ask them to revisit. For example, an absolute veto on publishing the results might be impossible if a member of your team is perhaps part of the PhD team or something, and clearly you don't want a PhD student to end up with a thesis they can't publish, but something along those lines. It's not the what you want to negotiate, which may be very reasonable or essential. It's somehow getting their other partner to the position where they're willing to negotiate at all. And again, that's to do with building a relationship, and it is possible. Moving the goalposts, I'm afraid that does happen quite often. And that's usually linked to the key people in the original negotiation at the table changing. And that happens, in my experience, it has certainly happened several times where companies change commercial operations, they change strategy, and or importantly, they change personnel. So sometimes you can be investing and shaping a deal or relationship that looks like a certain direction, and then somebody new comes in. There's not so much you can do to avoid, of course, your personnel on the other side changing. But if you can reach agreement and get some commitment at every stage of the way, then you don't necessarily have to go back to the very beginning to start all over again. The just say nothing at all, that's just a very quick throwaway line that when you, whether it's about money or any other key issues within the relationship, like how much of a sample quantity of chemical compound you're going to provide or whatever, there'll be certain things that you will offer as key elements of the deal. And very often what you get on the other side is silence. And I have to say from experience, please resist every temptation to fill that silence, because what you're then doing is you're jumping in to negotiate against yourself. So it's a negotiation tip which is relevant for all kinds of relationships. But I have to say that sometimes when you're sorting out things with other organizations who are very experienced in negotiating commercial terms, then the art of just saying nothing is something they can be very good at. So stand your ground and just encourage them to re-engage with you if you possibly can. External time limits and or real pressure can also play a role. This may seem like a really unexpected slide to find in a negotiation between organizations who traditionally surely really love to work together, and why on earth would there be physical elements involved in a negotiation? But we have experienced situations where companies have been very keen to set the scene in a way that we would be rather willing to agree with their suggestions rather than negotiate or argue or seek to amend anything. And so I'm afraid we have experienced humiliation. We've had to go to meetings without any accommodation for jet lag. You know, we've even had one of my colleagues was isolated in a crocodile surrounding swamp in South America and all sorts of places. So really interesting stories there. But again, naming no names, shaming no organizations. But, you know, it can perhaps
be 15 minutes, Laura.
Thank you very much, Lauren. That's really great. And so it's something to think about, that maybe our digital world might alleviate any of these risks. Then we've got to the stage of the final phase, which is, okay, we've done a deal and hopefully we're all happy with the commercial, legal and technical plans and commitments. And sometimes, and these are real things that have happened, that the deal is up and running and then all of a sudden a completely different company appears saying, well, I've taken over that contract from the previous company. And that is a very interesting development, and you have to be aware of, can you live and do you want to work with the new company? Whatever the reason for the takeover, is it something that you need to amend legal agreements around, or is it something you're entitled to say, no, I'm actually going to stay with my choice and revisit the contract with the original party? Clearly, things never work out as exactly planned. So failure to perform can be a real, either a real accusation or a challenge. And again, to do with the relationship and how you've framed things in your contract. Really encourage you to think about planning for things not working out, and that's where having good legal support is a good idea. We've had situations where we signed a deal with an upfront payment received, and then within 3 weeks, the company that had paid the money for the upfront actually was sold to another company who decided they did not like to inherit the deal. So they instantly asked for their money back, and that started a whole legal discussion, which really we'd much rather not have got involved in. And in fact, legally we had done nothing wrong, but they were sort of triggering a breach, which then leaves you a problem. So again, it's all about relationship management. And then the words that are used, and I know a couple of the other speakers will be talking about some of the clauses and the specific terms, but some of these are words. I've headed it up because for some things you cannot commit agreement at day one. You have to have an agreement to agree certain things, like what are the triggers for milestone payments, or maybe even what is the royalty basis. But be very careful that you don't misdescribe the scope of the group of people involved whose future outputs are involved. So you just need to be very careful. And hopefully with your lawyer, you're able to make sure that you use all the right definitions clauses of the technology and of the people and the departments and the groups and all of these things. Mutual consensus. Again, we can be using words which we think are very clear and straightforward, but in different regions might mean, in different cultures in the world might mean different things. Governing law, again, also interesting, and we can go into that in detail, but there are some really good and interesting challenges if you end up having to agree to a governing law that is one you're not familiar with. Background IP, is it just in a point of time, or is it also sideground IP, things which are outside the field but developed by you or the other side after the start of the project? And when we talk about exclusive rights, you know, do we mean sole? Do we mean non-exclusive? Do we mean exclusive? So these are some of the key areas where there can be or have been some confusion. So you just need to think about all the words that are used carefully and work closely as a team, always bearing in mind there's legal content and words, and there's how the relationship and what's practically going to happen. So lots of energy needs to go into making sure these things happen. And again, this is an unusual slide, which is very dramatically pictured or illustrated, but essentially these are things which have happened in the past, either by design or by accident. Confidentially has been broken. Contracts have deliberately been breached for commercial reasons, leaving you to work out how on earth you're going to seek redress. Third parties have taken IP. There has been a royalty fraud in the sense that people don't report royalties that should have been paid, even selling on the license for 2 million euros when there was no entitlement to sell on the license, etc. So these are all real life things which have happened in relationships. You should not be too scared that they happen on a regular basis, but equally when you're setting up relationships, you know, you have to be realistic that sometimes things go very badly wrong for lots of different reasons. So in terms of moving forward, it's a question of just trying to always do as you would be done to, because a deal is a relationship, and at the end of the day, the future can be just as important as the present when addressing how to reach settlement and agreement, but also more particularly how to deal with the many problems that will arise in the future. And the words on the page are certainly what will allow people to go to court, but actually what's more important is the relationship. And bear in mind, all of these relationships, whether it's for 6 months or 2 years, as we've all seen, especially in recent months, you know, the world around us can change very quickly and people can move on very quickly. So you need to make sure you've got a very clear record of what was intended so that it can be understood by subsequent people. Work as a team. You need to make sure the technical, the commercial and the legal are understood and on the same page, from the planning to the signing to the moving forward. And I do, of course, always recommend using a good lawyer, but let's talk about that as a definition at another time. It can never be a dull moment, of course, as many of you know, but lots of thought and planning and discussion and talk needs to go into setting up these relationships. And there can be a lot of good fun, a lot of heartache, but almost everything can be resolved at some point when you actually have a good working relationship, essentially with your own team, your own colleagues, you're all clear and have very good, clear lines of communication about all the elements of the relationship. Because it's not just about what's on a contract. It's very much what people can then want to do and will continue to solve problems together afterwards. So I hope that's going to set the scene without scaring you all. It's maybe rung a few bells, but I very much look forward to my colleagues and the next 3 presentations, and we can have a discussion afterwards. Thank you.
Thanks, Laura, for setting the scene and really going into the landscape of do's and don'ts in negotiation. Thanks. In the interest of time, I'd like to move on straight away to Martin de Kort. Martin's sharing his screen.
Okay, thank you, Nigel. I hope you can hear me well as well.
Yep.
Thank you very much. And thank you, Laura, for giving a lot of valuable insights in the dynamics and in really highlighting the complexity of setting up public-private collaborations and running them successfully. What I would like to share with this contribution on behalf of EATRIS is the experience. And I think as an organization in the last couple of years, we asked ourselves the question, to what extent can we structure the process and maybe reduce the number of variables and things that you cannot, well, let's say, control and control better towards successful collaboration. We're in the life science space, translational medicine, disease agnostic, very broad, but as a distributed infrastructure with over 100 institutions in 14 countries, we do have a few core principles in matchmaking. So bringing the industry and academic client together. That is having a deep understanding of the research needs of the user matching the relevant expertise, really take the time to do that. Also, the principle is EATRIS is not a legal entity per se in any collaboration. It is the client who decides, and EATRIS is a facilitator bringing the partners together. So actually creating the right ecosystem. Doing so, you really need to have a keen understanding of the different needs and to come to a joint, common field where you can have a 1 + 1 is 3 situation, I always call it. Academia, the list on the left, no need to go through them in detail, but I think it's clear that academia, historically more the open, creative environment, freedom to do research. But more and more you see, apart from the publication, it's also the valorization point, and the fields seem to merge with some aspects that normally were taken by industry, and especially the field, the value of death, step in a role for SME, and hence on the right, the industry part, more applied commercially, but there's joint or common themes like IP is no longer only something for industry, it's also for academia. And I think what we've also learned to appreciate is the different needs between SME, the smaller organizations, and the large pharma. The SME need to have the proof of principle, get to the next inflection point very fast, whereas large pharma are more interested in strategic initiatives. But I think what we've also learned during these interactions is really to ask the people in our network that we serve, what do you want from a collaboration? Is it about data or materials under MTA? Are you interested in the funding? What drives you to work with the other side? Do you have an assets for out licensing? Is the TTO pulling anything from the labs? Or is it in licensing something that you need to get something done? Or do you have other reasons? And what do you have to offer? Do you have the specific results leading to a potential product that you need an industry developer for? Is it the specific data, the specific platform, any IP? Is it a product or a platform? Or is it the specific skills or personnel that you have offered? We have wonderful examples where we have labs almost like CROs that have the specific skills. So these are the questions that you have to have to ask yourself. So in terms of structuring the process, it is always important to know where you are. EATRIS has been kind of the middleman in this process. So it comes with, of course, many things are happening. There are warm contacts, cold contacts, B2B meetings, but at some point you have to start. At EATRIS, it starts with either a confidentiality agreement or a letter of engagement. And then it's really becoming concrete. What do you want and what can we offer? You can apply this to your own situation probably as well, single institutions with complex departments, but the second step would be to identify the partners. Within a distributed RI like EATRIS, we would go in Europe, but you can also do that on a broad academic medical center site. Then the client decides to which partner it wants to talk to and explores the project. Because this is I would say the negotiation phase a little bit, and setting the scene is really where the science should drive a project in the right direction. And the last step towards project initiation is really nailing down the contract to simplify it. And I think having this process in mind, the phases, whether you name them like this, and once take a moment to ask yourself, are the partners still on the same page? It helps to keep the pace and the momentum in the collaboration. So as I said, I think the science should drive the process forward. with the research question, the partners, and build the project. Even pilots could already informally start during this process. However, it's not so that once you want to start a project, you have to engage with the other players. There's business development, there's IP to be discussed. There's many aspects. So during this process, you have to consider already including the right stakeholders and later conclude with the legal process. This is an example of a collaboration that I will come back to later. And it means that there's a parallel process where you look at, let's say, the legal aspects and scientific aspects. And throughout this phase, until the formal initiation, a lot of questions, almost like a checklist, come to mind. What are the common goals? Who takes the decision? Who pays? Etc. etc. So it all comes down also to nailing down in detail what are the roles and the responsibilities. And the more complex the projects, the more partners involved. This might already be asked during the project formation phase. Is there a negotiator? Is there a broker to facilitate this? And it speaks for itself that the more complex, the more support is needed. And then ultimately also the choice of the collaboration type. This is a kind of a busy slide, but there's the different models already referred to by Laura. It can be research collaboration, it can be licensing, it can be contract research, or it could even be a decision to spin out or create a startup. And depending on the parties involved, the dynamics and the number of support that you can get during these negotiations also plays a role. The objectives are pretty clear, should be clear from at some point. You can match a need, you can have excitement, you can have the science all over the room, but it's important to keep in mind what the objectives of the collaboration will be. Is it about the knowledge generation, or is there a commercialization factor? And what about the benefits to society that more and more requires the public-private interaction? The scope, obviously, as well. So I think this is familiar to most of you, but having this on the radar structures the type of collaboration that you're after. An extra word on pre-competitive collaboration, because this is, especially in the academic environment and also with EC-funded programs, a topic that needs attention. I think there's different types here. You can think of sharing of data and consortia for platform technology development, really joining forces for, let's say, common sharing and teaming up, and maybe even establishing open source programs to accelerate innovation. But it's also important to think about the exact definitions if you want to turn it into agreements. So open innovation is quite a broad term, whereas open source refers to specific arrangements with licensing types, but in fact it's not completely open. It comes with some grant back improvements, and then there's open access, which refers to the data and also the reproducibility issue in association with publications, obviously. So I think so far I've touched upon a number of aspects. I would like to finish with a couple of short examples that we really have experienced within EATRIS, from simple to more complex arrangements. So this case was a French biotech approached EATRIS, oncology company. They had some interesting findings, and they wanted to shift from an oncology to a neurology target. So we matched them with a couple of institutions. CDA, TCs were established. It took about 5 months. It was relatively fast, I would say, from the first interaction. It was a modest service agreement involving a 35k euro service type of collaboration. And what went well was the matching of expertise. We had multiple sites that we could offer. And the results could actually be used for go-no-go decisions in their drug discovery. And that was the plan. What went wrong in this setup was that actually when it came to do the work, the key cell models and the genetic constructs necessary to do the experiments were not accessible, although these were promised by the institution. What happened was there was a license needed, and the license was restricted. And in fact, it was a third party that was claiming and owning this. And the impact in the end was limited because the specific reagents could not be used. A second case was a more complex case where we had a Belgian pharma company, UCB. They had a request to perform fibrosis imaging. This could not be delivered by one site, but here the size of the network could help out. So we had 2 sites, one in Finland, the University of Turku, and one in Amsterdam. And this brought some complexity in the exploration phase. We were successful in initiating a 2-year project. There were some different dynamics here than an average project. I would like to focus here on actually the smileys. So there was a good thing here that the key opinion leader and actually a key opinion leader from our network could convince the pharma company to engage with the institution. It was really a key driver here. And there were 2 institutions that were lined up. They were collaborative, also positive aspect. And within the company, there was a clear project champion who believed in it. This is also very important to recognize who are the project champions. What went less smooth in this project initiation was during the contracting phase or the building of the project plan. The owner of the project plan was less clear. Because of this complexity of multiple partners involved, EATRIS took a broker role and at some point owned the project plan, but then later in the project champion in the company stepped in. This took some time, I think more time than needed, but in the end, a successful collaboration started and a more relevant model to guide the specific research questions was available. In the interest of time, I will go very fast through the last slides. This is the most complex collaboration that we put together. This is a consortium with 8 legal partners. It's a collaboration with GlaxoSmithKline, focusing on immune inflammation imaging. And here you have this picture of the parallel scientific and legal process, which really helped to put together this master research collaboration agreement. This is not a single project description. However, this is a framework where you can have a multiple different type of projects for which the individual terms have been pre-negotiated. So that means that in terms of project initiation, you only have to agree on the content, and then as a work order type of initiative, trigger a new project. This works among 6 academic institutions and a pharma company. And the other advantage is that you have a very clear structure during the operations phase.
Martin, this was 15 minutes.
That was 15 minutes. Okay, so then this is the last slide. There are, of course, advantages and also some challenges here. If you have a larger consortium, there might be more unpredictable events happening. It's also more difficult to keep up the operations, chasing the right people. Also, the legal contacts sometimes are hidden behind innovation help desks, whereas it always works well if you have personal relationships. The costing structures are more complex, and also on the academic side, what you see, which really impacts a long-term collaboration, is the temporary staff. So PhDs and postdocs moving on, and the projects still continuing, and that is what I think is to be managed, but you need to manage it, I think, proactively. Then on the pharma end, it's sometimes the slow decision making, the red tape, and the R&D restructuring, which can then again frustrate the academic side. And finally, in this specific innovation hub, we had quite a number of third-party external interactions, which also led to some unpredictable events that really impact the project. So always have a plan B in mind. With this, I would like to conclude and thank you for the attention, and available for discussion at the end. Thank you.
Thanks, Martin, very much. What I think comes through clearly are the different types of possible collaboration, and also the time element. Sometimes it takes a lot of time and planning, and that's an aspect, perhaps something for the discussion as to how to plan the time towards a deal. Thanks again, and our next speaker is Tamara. Carapina.
Okay, I had to unmute myself. Sorry for that. Welcome everybody. I think that Laura's and Martin's presentations fed really nicely into my presentation. I will address the middle stage of what Laura was mentioning. So not setting the scene, but negotiating, and negotiating in a way so you are able to live with the deal afterwards. I'm drawing my experience from 5 years working at EATRIS and facilitating negotiations and contracting between public and private partners. Here on a slide, certain legal aspects that I want to address today one by one, and offer you some tips and best practices on how to approach those and eventually negotiate those. So first of all, possible deal breaker are lengthy negotiations and complex agreements, complex arrangements that do not end up in a collaboration at the end. The more the merrier, but you know that the more partners, the slower the process gets, because there are exchanges from a lot of different parties, and at the end there are a lot of legal departments that have to discharge and approve on a final agreement or a contract. How to approach those, some tips here: negotiation in steps. There are some instruments that you can help yourself with. I will talk about term sheets and use of templates as good starting points in further slides. Also, a good tip is, yes, science should drive the process, but a very warm advice is to have a real-time person dedicated to drive the process as well. Because sometimes you feel some parties are very promptly replying to emails, but there is radio silence all of a sudden on some other end. And it doesn't mean that it's because of some very important issue, but there are other contracts and deals going on in institutions, and people forget to reply. Sometimes there are situations of lost in translation, so something that gets lost in the mail correspondence, you need to organize a telco or a meeting to overcome. such situations, very good to have a coordinator, which can be a third party, but also can be very well dedicated person from one of the parties which are negotiating the contract. Also, it's very good to predict which kind of collaborations and projects can come in a future in order to choose appropriate legal framework. If you are sure that this is a one-time deal and project with this certain party or parties, then you go for negotiating of a project-based specific agreement that ends at the end of the project. However, if you can predict that there are more projects that can come in a pipeline and you would like to collaborate with certain parties on a longer term, then it is good to have a framework agreement. Martin already mentioned one innovation hub where you pre-negotiate all the important clauses and then you can execute project agreements through the years in a different tempo when some good science comes in. Also another tip, I'm not saying here that legals from institutions or companies should sit at the initial discussions or that the legal issues and more legal causes should be addressed first. But I'm saying here that legals should be at least informed by their scientists or business people driving the discussions, so they can predict and overcome certain situations that can lose significant time later. For use of templates or model agreements, I say yes, it does save time and it's a good starting point. Whose template, Laura already mentioned, private companies, they do tend to prefer to start negotiations on their templates because they developed and established those, and for them it's time saving to negotiate on something which is familiar. And this is okay as long as it is not take it or leave it situation. And as long as you can negotiate and tweak the clauses to meet interests of all the parties. Confidentiality agreements are the easiest one to template, not a lot of modifications needed. Other types that can be templated are material transfer agreements. When we come to collaboration agreements, this is a more complex situation. Here you can maybe template core aspects. Here I provided one website where we developed few templates under the Corbel project, and you can see them and see if they can, if those templates can be helpful as certain starting points. Also, DESCA is one template of consortium agreement that is very well known and endorsed by the community who participates in Horizon 2020 and now Horizon Europe projects. But also other grants like IMI, which is Innovative Medicine Initiative, or I gave an example of a local Dutch one, Health Holland. They all have consortium template agreements, which are good starting points, and they actually, the grants prefer that the consortium are concluded based on those templates. On the other side, I have put but. Why but? Because there is no magic template that can solve every real life situation. So every template needs to be adjusted to the specific circumstances of your case and of your collaboration. And of course, professional assistance is strongly advised in drafting the final legal texts. Term sheets that I mentioned. What are term sheets? Term sheets are one instrument that can help you negotiate complex projects which cannot be negotiated in one single step. Also, some institutions and private companies prefer this kind of process, and they are usually in a form of a table. Contents vary depending on which type of agreement you are negotiating, but basically it contains all the key terms or aspects that need to be addressed in a future agreement. I here have put one example, just for you to see. This is a term sheet for licensing agreement where you have already fields that you can either tick which kind of license. You have an indication of who is licensee, who is licensor, and you have intellectual property rights listed that you can tick, and sub-licensing rights, yes or no, is it unlimited or fixed, and so on. This is not the complete term sheet. It has 5 or 6 pages. What is interesting that at the beginning you have a disclaimer, which is quite important, to say that this is a non-binding overview, so agreement to agree and not final and binding agreement. Confidentiality settings, also some tips on how to set it up. When, of course, before you sit at the table and can disclose your proprietary information in a relaxed manner, not fearing the breach of your proprietary information. Whose template here in confidentiality agreements? Template is usually offered by the party which considers itself to be the main disclosure. However, I always recommend, and I see that it's well accepted, if even the party who is more of a recipient in this relationship asks for a mutual confidentiality agreement, which contains a language protecting equally both parties, which can share proprietary information. Scope of the confidentiality agreement should not be too broad or too narrow, because then it's impractical for the recipient. If you are not specifying what you are discussing about, then later on you cannot prove if what you were discussing about and if you breached or not the confidential information. Agreed purpose should also be always defined. That means that you should you can use this information you're discussing about for only a limited purpose. And it's always also good to list to whom you are permitted to further disclose. So apart from your employees on a need-to-know basis, you also, if you have a need to use external experts, then you should allow yourself a right to do so under the confidentiality agreement. Of course, then with such external consultants or experts, you have to have additional confidential agreement on the side, or a consultant agreement with the confidentiality obligation to cover and to close the whole process so that confidentiality is secured and maintained. Several bilateral versus multilateral CDA agreements. Well, if there is more parties which are discussing the same possible collaboration, I think it's more practical to have one roof confidentiality agreement, which all the parties will sign. It can be 4-way, 5-way, however the situation is. It's more practical than having more 2-way confidentiality agreements. Duration of the confidentiality agreement as such does not have to be very long. It is the time that allows you to discuss, so it can be 3, 6 or months or 1 year. However, the confidentiality obligation is a different thing, and you set those to 3, 5, 7, 10 years from the expiration or termination of the confidentiality agreement. I have put here negligence because I saw many confidentiality agreements which say that that confidentiality breach will be considered as such only if it's done in willful misconduct or gross negligence. But basically in practice, confidentiality leaks happen in a simple negligence and recklessness. IP arrangements. In negotiating agreements, what I want to say here is that you don't have to negotiate basically every single detail in an agreement, in a collaboration agreement. However, it's good to set the intellectual property principles that will guide the relationship later on. So some of those that are good to define upfront is to define the foreground, and that's the result or the outcome of the project, which can be IP sensitive and it can be protected as an IP. To define the background, and that's all the data, know-how, or possible IP that each party owns before entering the project, and it's actually supplying to the project because it's needed for implementation. And sideground, this is also can happen along the way if it's developed by one of the parties to the agreement, but it's not really in the scope of the agreement. That in that case, this sideground created belongs to the party which created it. Also, it's good to define ownership principle, meaning if the ownership will follow the creatorship, and what will happen if more parties create one single foreground or result, in a way that you cannot clearly separate each party's contribution. In this case, there is a joint ownership, and you can also predict in the agreement that in case of joint ownership, parties will later on conclude a separate joint ownership agreement to decide how they will use and exploit such joint ownership. You can also pre-negotiate in your collaboration agreement. Then in absence of such additional joint ownership agreement, you will follow certain rules on joint ownership. For example, that all of the joint owners can use such jointly owned result for internal teaching or non-commercial research. However, if you want to exploit it commercially and grant non-exclusive licenses to third parties, then you will ask a permission from other owners of such results, and you will compensate them with a fair amount. Sorry, I flipped it too quickly. One other thing I wanted to mention, you can also already in the agreement define access rights. So the rights that you allow to either results of a background, and you can differentiate access rights for project implementation, in which case you are granting access to other parties to results and background on a free royalty basis, while for exploitation purposes, you will again negotiate fair compensation. I see I'm already at the 15 minutes. If
Exactly.
Laura.
Thank you.
Okay, thank you. Continuation of IP arrangements. Here I wanted to show a differentiation with two types of research agreements, contract research, which is service for fee. For example, company outsources R&D activities to a research institution or university and pays for such activities. In this case, company will own all the foreground or results which are coming out of such project. But for example, institution can negotiate for itself that it can have foreground used exclusively for education and non-commercial research purposes. Background always remains with the party who supplied the background to the project, and institution can also negotiate under the publishing policy clause, which I'm gonna address later, conditions on which they can publish on the results and on the project. Collaborative research, on the other side, is more collaborative type, where all the parties are jointly defining the research project and input in terms of human resources and finances. Here, ownership is usually defined by inventorship, therefore it belongs to a party that generated the result. Background is the same, remains the ownership of the party who supplied it. But here, for example, a private company in a collaborative research has the right, and this can be put into the agreement, to later on negotiate exclusive or non-exclusive license to institutions foreground. Therefore, the foreground that institution created in such collaborative project. Publications will also follow publication policy agreed. Last, on IP arrangements, 2 legal instruments for management of IP. Assignment can be best compared to sale because it's a permanent sale of intellectual property asset, and assigner, the one who sells it or assigns it, can no longer use IP. However, the assigner gets a payment lump sum in return. Assignment is usually used when IP owner has no capabilities to commercialize the IP asset themselves, and they would like to realize immediate cash flow. Good example of assignment are spin-outs from universities. On the other hand, license is more comparable to rental because it's limited in time. You set the time in a number of years, 1, 3, 5 years, it doesn't matter. And depending on the type of license, licensor can still use it. If it's a non-exclusive license and if it's a sole license, then licensor can use it. If you grant it exclusive license, then a licensor can no longer use it. Exclusive licenses are therefore more lucrative, so more expensive. Territory and scope is also very essential because you are granting the license either for one country, Europe-wide or worldwide. Payment here are usually royalty payments, so percentage on sale on profits, but it can also be a combination of the lump sum plus the royalties. When license is used, it's actually a good instrument to turn potential competitor into partner and to remain ownership while getting a regular income without having to invest in distribution, marketing, or production. One example that I provided is the technology transfer. Here, one of the clauses which is always in agreements, which is dissemination and publication clause versus confidentiality. Here, obviously, private and public partners have different interests. While public partners want to publish and want more open result, industry partners, of course, want to protect the result and the outcome and potentially even file for patents or keep it as a trade secret. So how to make these differing interests meet? It is possible. We have experience that you can agree on certain periods to delay the publication, but still allow the publication. And these periods can be gradually set, that 14 days is, for example, okay to review the abstract, 30 days for a paper. If there is a confidential information for industry partner to be removed, then delay can be up to 60 days. And if there is a patent application to be filed, then maximum 90 days delay. If project is granted from any national, international funding bodies, that of course there are always dissemination and publication requirements in the grant agreements. Third-party involvement, mentioning here, Martin already mentioned, because we had experience with this. This can significantly slow the process if it's not predicted in time. Third parties are parties which are not contracting parties to the certain agreement, but you need them for certain reason, either as a subcontractor because party to the agreement cannot perform the whole work or service themselves, so they have to subcontract part of it to another provider, or you have some rights or materials needed for your project which actually have to be green lighted and licensed from a third party. This is really something that we are drawing most experience from, because we had live examples that this can really slow the process and even endanger the process if not properly handled. And at the end, governing law and jurisdiction was already briefly mentioned. This clause can also cause significant time in negotiations, although I think that this shouldn't be so. If all parties are from the same country, then there is a no-brainer. You will choose the law of that country. However, if you have 5 contracting partners, all 5 from different countries, then there will be push and pull around the law to be chosen. A good example to go around it is either to choose a neutral third-party law, or if this is also not easy to agree among the 5 different parties, then my recommendation is always to choose the law of the defending party. That means that the party which is going to be sued at least can defend itself under the jurisdiction which is known to the party and in the local courts. Also, I don't like to spend much time on negotiating this clause, because in my 18 years experience and a lot of contracts, this is really rarely triggered, because even if there are potential disputes or conflicts between the parties, everyone likes to settle it without going to courts. For jurisdiction, I put also, jurisdiction is just the choice of courts in the under the law that you have chosen. So if you have German law, you choose a certain, like Berlin as a city where you want to go to court. But however, now there are alternative dispute resolution mechanisms which are more flexible than the courts themselves. There is a mediation, which is a softer procedure where you sit at the table with the mediator and maybe resolve your problem without many costs. Arbitration I also prefer over courts because it's faster. It doesn't have to be open to the public. And you can have arbiter with relevant niche experience according to your situation. Here, I hope that I managed in 20 minutes and haven't breached the time too much. Thank you.
Thanks, Tamara. Very comprehensive presentation. And I should mention to the participants that this is actually distilled from a much longer lecture or series of lectures. So thanks for your efforts to do that. And I give the floor to Victor for the final presentation.
Okay, thank you. Am I unmuted? Yes, it looks like. Okay, thank you, Nico. Thank you for inviting me for sharing the experience acquiring data project with you. As compared with my predecessors, when I was presented this topic, I was overwhelmed by the size, because actually resolving issues on the path to public-private collaboration is such a large topic that I decided to focus on some empiric elements from our experience, and rather on the conditions and the mindset that companies need to have when they are facing the public-private collaboration with a big science project. So I'm just providing my experience, or providing some elements of my experience in the big science context. Hopefully, well, I have seen in the participants that there are other participants that have also some relation with the big science project. So maybe during the discussion that they can share with me whether they agree or not with the approach. First, I will provide you some context from where I'm coming so that you can understand what I'm talking. So I am at Fusion. I'm working at Fusion for Energy. We are an agency created by the European Union to provide the contribution of the European Union to the ITER project. The ITER project wants to demonstrate the scientific and technological feasibility of fusion for energy. So we have our headquarters in Barcelona with staff of 460 people around, who are devoted to expend around 750 million euros per year on procurement. So we have a supply chain of around 750 partners across Europe, mixing prime contractors and subcontractors, with whom we are dealing on a daily basis in this public-private collaboration. So this is how the project looks like. We are very proud of it, even though we are a bit late, but lots has been done and lots needs to be done still. And I hope that maybe some of the participants will be our partners in the future. But let's move now into the lessons that we have learned at Fusion for Energy during these last 14 years of dealing with industry. The first thing I think it is important to mention is the context, because when dealing when an industry is thinking about dealing with a big science project, they have to understand the context. As compared with my colleagues, for instance, we are not able to have maybe models that can be decided or some flexibility here and there. We have some objectives, very clear objectives. And these objectives is what dictates the conditions under which we operate. For instance, I would like to say, well, in our case, we have been given the responsibility to build something or in a very specific time frame. This is a big difference as compared with other broader programs, such as Horizon Europe, for instance, or other public research programs, where you have some clusters addressing different areas of science, and then the companies have several options to choose when deciding whether to participate in these programs. You choose, okay, my skills are more here or more there, and then you have some flexibility. In our case, in a big science project, however, our needs are dictated by the advancement of the project. So sometimes we are often approached by capable companies willing to cooperate with us in the project with their knowledge and skills. And this is fine, but the problem is sometimes these companies, we have to tell them, well, your skills were required 5 years ago. This stage is gone. Or maybe that we will not need you in the next 2 or 3 years. The second option is better because then they can be on standby and come later. But the thing is that big science organizations are project driving, and the timing and the project management is very important for us. So we don't have much flexibility at the time of deciding which kind of contract or which kind or which kind of component we have to procure at a given point in time. Another typical feature of a big science project is that technical challenges are also big, are high. And the challenges are high, and the technical risk as well. So the companies involved need to be innovative, and they need to be willing to face challenges. There are fantastic and very solid companies out there which are not willing to take any risk because they are doing their business very well, and they may not be ready to take the extra mile required in a high-tech project. And sometimes we deal with these companies, and you can almost hear all the gears of the machine screeching when you are asking them to go beyond what they are used to do so far. So in the end, no effective collaboration can take place if the partners are looking into different directions. So a stable company, very good company, which is not willing to take the extra risk of a big project may not be the ideal partner. And sooner or later, there will be issues. There is also the issue of the financial capacity. Well, when we are dealing with big science, sometimes there is also big money involved. So we have sometimes big contracts that amount to several hundred millions, for which we need the companies to team up with others so that they can withstand the financial muscle required to face such challenge. This again requires a specific mindset, because you need to be willing to cooperate with others for this undertake. This is not always the case, for sure, because we have some smaller contracts as well, which are within the reach of SMEs. In any case, something which is applies to both is that when a public body like us is getting into a contract, we are usually very greedy about details. For instance, about details on the financial health of the company. We are asking a lot of things, and we are doing so because we have to do it because we are subject to public procurement conditions. And this might be distressing for some. I'm referring to this in particular because these days we have had, well, we are in the case now. There are a couple of companies which are being evaluated within a call for tender and which risk being disqualified because they have not provided all the requested information from their balance sheet. This, for them, maybe this is something that they consider a minor issue, but for us it's a no-go. So a perfect capable company is going to fail in a call for tender on these administrative grounds. So this is something that companies approaching to us that they have to bear in mind. We have no flexibility because we cannot have flexibility. It is actually, well, I am in the office today, even though we do a lot of teleworking, but I am in the office today because we have the European Court of Auditors coming to our premises, well, to investigate as they do twice a year. And this is so because being a public organization, we are subject to these kind of controls that we have to impose also on our contractors. So finally, I want to refer to the long lifetime of the standard big science projects. Big science projects usually take lots of years to be achieved, and this is both an inconvenience and an advantage. The inconvenience is that we need companies that are capable to commit resources and capabilities over many years. But this also constitutes an advantage in the sense that once the relationship is established, we may be considered as a stable and safe customer for quite some time. But on this, the company needs to decide whether they want to be with us to marry us for some few years. In the end, some of you may consider that all these elements that I have just referred apply the same to any civil engineering project. For instance, it is not so different from creating a bridge or an airport or a highway. And maybe you're right, the difference is that big science is unique, is the uniqueness. Again, this is good and bad. This is good because being unique, competition may be lower because there may not be so many companies willing to get into this path. But also the market is smaller. So these are considerations to be taken into account when getting into a public-private collaboration in big science. And the key to resolve any of these issues, if a company is thinking whether they want to be committed, it is communication, but communication with big letters, and not any kind of communication, but effective communication. As you know, effective communication is not about merely making information available to the other party, but also about ensuring that the message reaches the other interlocutor in a way that it is understood and serves to the purpose. As I was referring before, since we are dealing most of our collaboration with private companies is done through procurement contracts. So communication between the partners within the procurement conditions are very well established and they are very stiff. So there is very little we can do on this. We have the means we have. And sometimes companies may say, well, okay, but this is not sufficient to cope with all the questions mark that I have. This is why, for instance, some big science organizations, and this is the case for us, we have implemented some other tools to make sure that the flow of communication, the flow of information with our companies is open as much as possible. I'm referring here to the pre-procurement activities, for instance, which is also called market consultation in the procurement directive, or to the discussions after the closure of the contract, the supplier relationship management that we are carrying out. We have a program for this. This serves the pre-procurement activities. This is something that we are doing in my group. There are 2 persons devoted to this. And what we are trying to do is we extract information from our project teams. We try to understand what our technical people is asking to the market. And we try to translate this information for the market to understand actually what we need. And in the same way, we are taking from the market communication so that we can feed our technical people. The idea is that by the time when the procurement is coming into life, when we are doing the call for tender, we are publishing, we are matching what the market is ready to provide us. Otherwise, and we have had the case in the past, that we were willing to, procure something, and the procurement, it was deserted. There was nobody appearing because we were not aligned with the market. And this is an example of ineffective communication, maybe the reason why we have developed this pre-procurement analysis. Once the contract is done, well, I'm not dealing now with the relationship between the public and the private organization during the procurement or the contract implementation, because as Laura was referring before, well, once you are in the deal, you have to live with the deal and you have to live within the rules. But once this is done, then this is over and the procurement is delivered, then we want to have discussion with our contractors to have information for what went okay and what was not so okay. This is important for us to streamline our procedures and also to make sure that we are better, or we are ready for the next time that we have to launch a call for tender. And these 2 elements, the ones that I'm referring, this is our responsibility to put these means into motion so that we can have an open discussion with the industry. But there is also another side. It is the responsibility of the industry, your responsibility to be present there. For instance, we publish every now and then a market surveys to understand what the market can provide, or we have info days. And we have established a very clear relationship, a very direct line between the people who is participating in these activities and the people who is awarded a contract. The more you come, the more you know, and the better opportunities to being awarded a contract that you have. After 14 years, it's true that there are already some champions, some companies that are appearing over and over, but it is not because they are better, but because they are better informed, because they are committed and they are willing to be in communication with the big science organization to understand what we need so that they can deliver. In the end, this comes to participation and commitment. So, I just want to also to refer about the motivations of your business partner. Sorry, this slide may be similar to one of the slides that Martin was showing before about the objectives, which are the objectives of the public and the private organizations. I believe that it is, well, in this slide is not so much about objectives, it's about the drivers, what we want to achieve, why we are dealing with the private sector. In our case, is because we, as I was mentioning before, we want to fulfill a big science project. But there is something very important that private companies should not forget. We also have to comply with other criteria. We want also to make sure that there is social benefit from our activities. And we want, at least in the case of Fusion for Energy, for instance, we have an industrial policy. What does it mean? Industrial policy means that we have 3 objectives in FRV vis-a-vis the industry. The first one is that we have to count with the industry for delivering the project. This is clear. But the second one is that through our contractual activities, we have to make this industry stronger and more competitive. And the third one is to make sure that this competitiveness is based on technologies that they are developing. So what I mean by this is that when we are establishing a relationship with a private company, for us, it's much more than a commercial relationship. For the private company, it may be that, well, we have a contract here, we want to achieve, we want to have the money, and that's it. This is fine. But in our case, we want to achieve something else, and it is to make sure that we have an impact on the society. This not only because this is part of our industrial policy, but also because big science projects, we are also competing with each other for the funds, for the money. And we have to show to society that there is a return. So we are willing to give money away, not for good, to have some return on investment for sure, but we are willing to have contractors that are as successful as possible. So it is in our bylaws to have successful contracting partners.
We've got 15 minutes.
Yes.
Is it okay?
Yes, great. And then this is my last slide. Well, I wanted to make reference to technology transfer because we are also dealing with technology transfer within our group. And because I was reading not so long ago something by a lady called Lita Nielsen. She was the director of the technology transfer program at the MIT in the Massachusetts Institute of Technology until 2016. And she was referring to the fact that in the MIT, only 4% of their budget, it is coming from royalties. So they are the winners in the world in technology transfer, but only 4% of the income is coming from royalties. Because for them, it is very clear that technology transfer from public institutions is not about money, but it is about having impact in the society. So this applies also to us when Fusion for Energy, and I have been asking also the CERN, the ESA, and some other big science companies, when we are embarking into technology transfer, it is not that we are looking for having a very good commercial and economic results. We are willing to have companies that by dealing with us, they are becoming better and they can show that to the society that they are really successful again. So all in all, to keep it short, when big science organizations like Fusion for Energy, when we are trying to deal with companies, we are not only looking into the money, we are not looking also only into the project. We are really looking into establishing a long relationship with partners that will be together with us for quite some time, and that will be committed enough to, well, to get to the termination of the project. So I've been talking about commitment, about communication. I think it's like a marriage. It's a psychologist talking about marriage. You have to commit to be truthful, but this is it. So we establish long relationships with our partners, and the more successful they are, the more successful we are. So that's it. I think that we are done with the time. So I think that now, Nigel, no, you will open the floor for discussions if there is any time left, which I don't think it is the case. But
thank you, Victor, very much for the view from big science organizations. Fascinating where they stand and the future. We have very little time left for discussion, but I will open it up to discussion. But before doing that, we can continue the discussion on social media. ENRIITC has a LinkedIn link, and you're all invited to send any questions or comments by email or engage in discussion on LinkedIn. And Laura MacDonald has in the chat raised the issue of we would love to hear from all the participants at which phase in this whole process they encounter difficulties or successes, that would be very useful. Also from the point of view of ASTP whole webinars themselves, and as a general point, in Tamara's presentation, there were also some references to sources of help. And I think that's a take-home message. You're not alone. Look for help. It's available many resources. There's a European Commission IP and valorization help desk. Within the RI networks, look at the Life Sciences RI link. There are opportunities to get help. I've said enough. Let me invite now any questions from the participants or comments. Well, I have one. I think to Laura and Tamara, the issue of patenting has come up. What do you experience as the most important issues around patenting in terms of who patents and who pays the patent costs? Any thoughts on that from your experience?
I don't know if you want to go first, Tamara, or...
Oh, go ahead. Yeah.
Oh, okay. So in a nutshell, yes, have experience. I think, Tamara, your slides illustrating the difference between the, let's call it contract research and collaborative research, is also usually, in my experience, a very good starting point for whatever general principles are captured in the agreement. In my experience, and it's not just because I have traditionally worked for an academic or research centre that I feel, I want us to be the owner. I mean, generally speaking, the wording in many of the collaborative agreements separates out three different things. First, ownership of the right to the subject matter of what might be a potential patent. The second element is the decision-making process about what could or should be patented during the life of the relationship. And the third element, of course, is, okay, what then happens to the rights to use the patent commercially and all the rest of it. And usually the principles that we have found to be very workable and highly acceptable to both commercial partners large and small and our other collaboratives, so it works well in a bilateral or consortium scenario. And the first one would be that usually first ownership sits with the organisation employing the actual inventors of the patentable subject matter. That then means you immediately at some point will have to perhaps get a bit of an expert opinion on that, because of course a patent content will be different from a scientific publication or an overview, a summary of all the results generated. So patentable subject matter, first ownership, employers. However, if it's developed within the scope of a collaborative relationship, absolutely you want to have a discussion with the partners. And unless the partners are initially willing to commit to the full downstream development, utilization and commercial application of the patent from the get-go, from the application stage, that's a difficult commitment for a company. So usually the filing decision will be made jointly, but maybe the costs sit initially for filing with the inventor, with the owner, sorry, or the partner owners. And then the real discussion is, hopefully in your agreement you've got this mechanism that allows joint decision making for future planning about what should be filed, when it should be filed, and therefore what options, rights the partners, the commercial partners have to step up at any point and say, hey, certainly during the life of the project and certainly within a period of the end of the project, to say, okay, now we know what this looks like, we have a vision for how we'd use this commercially, with some structure on how to access that, as Tamara said, balancing, payment perhaps for downstream commercial use. So I think it's about ownership, it's about having a mechanism on making decisions as to what's filed when, and having a mechanism on decision, go, no go, yes, no for commercial use, leaving the owners in the driving seat should the partners not either want at all or not want to take the entire scope of use. I think maybe that's a very long answer to your question, but it's a mechanism or a process that we have found works rather well to encourage discussion and decision making, which is important.
Okay, thanks. Tamara, anything to add?
Yeah, just to add, between the between the two different types, that in contract research, where a company is basically owning the results or foreground, they will be in lead of filing the patent and paying the costs. While in collaborative research, where there is many parties, we also have a lead party named in the agreement who will facilitate the process and coordinate the process. And of course, in collaborative, as I said, there is always agreement to agree later on how this will be exploited among the joint owners, or the licenses to be obtained by the company, but compensating the public partners from the collaboration.
Okay, thanks, Tamara. Any other questions?
I think there are a few questions in the chat.
Yeah. All I can see are people thanking us and leaving. Anything else? Am I missing
There's also
something?
I think Martin had a really good question, probably particularly addressed to Victor, about what's a major rate limiting factor in the transition from the public-private collaborations, which Tamara and I maybe focused on, to the big science projects as Victor talked about. What is the major, if there is indeed a major rate limiting factor to getting the project done? So I think that might be worth hearing.
You're referring to the questions that you put in the chat? The
maybe I can reflect on it. I think it was interesting to see a lot of things are focusing on the one-to-one interaction between a public and a private partner, and I think that is an integral part. But the last talk by Victor really explains the different dynamics. I mean, a big science project, you have a bigger role for the government and in even the public, so referred to as the triple or quadruple helix models. So I was wondering if there is a general rule of thumb, maybe Victor, if you compare the experience of CERN or the Fusion for Energy project, if there's a general rule of thumb of what is the rate limiting factor. You refer to as communication is an important element, but maybe there's something else that always seems to be keeping most of the time, which can be improved if you organize that better, or maybe on the basis of your experience.
Yeah, well, yes, there's something which is a deterrent for many people, and it is actually bureaucracy, which applies to all of them. But it is not only for big science. I think that any public administration has bureaucracy, and we are well known for having big bureaucracy, red tape. But on this, there is very little to do, because since we are using public money, we are subject to many controls, and there is no way out. The one thing that I may mention on this is that in our experience, the companies usually, when they are bidding for one of our contracts, it is rare that they are awarded the contract the first time. It is rather that they manage to have, in average, the second time they may have a contract. But once that you have gone through this learning curve and that you know how to deal with all these, then I will not say that it is piece of cake, but they are so knowledgeable that it comes more easily. So once you have managed to get awarded one contract, then things go smoothly. So this is maybe a big well, deterrent at the beginning, but with the time it can be solved. And there is one of the questions Laura was referring to. It is the thing about finding partners, sorry. Well, for us, finding partners have been sometimes a pain in the neck, because we are not buying things that are out of the shelf. You are not doing that either. But sometimes we are trying to buy something that nobody has done before, and that maybe that nobody is going to do again in some few years. So the market is very limited, and the interest of some companies to really get into these problems are limited as well. So this is why we have to do a lot of work at the pre-procurement phase. We have to make sure that we are matching the needs of the companies, of the industry, and that if necessary, sometimes you have to split a big contract into more manageable elements, so that you can spread this information or these pieces of contracts to people that are ready to go for it. Some other times we have to foster the creation of some consortium, so that people is teaming up to provide what we are looking for. Which one may say that this is actually, we are creating competition against our interests, because we are creating a consortium, so they are going to counterattack. But in the end, again, that it pays off, because as I was mentioning, within our industrial policy, what we want to have is more competitive European industry. And this is giving this industry the possibility to meet other counterparts and to grow and to become more efficient. So in the end, one day when we will have this fusion reactor working, we will not only have this fusion reactor. Next to it, we will have, hopefully, a supply chain of very powerful industry in Europe that will be leading the next step, which is the commercialization of fusion. I can imagine that maybe 60 years ago or 50 years ago, when fission was being developed, we were in the same place. Or maybe 40 years ago, when the aerospatial industry in Europe was being developed, now we have people launching rockets, and we have satellites, and we have ground services. But this took some time to develop, until now we managed to have a supply chain and a powerful European industry. So this is going hand to hand. So I think that we will be successful in both.
Okay, thanks very much. Any other questions from the chat that we need to deal with? If not, then I think in view of the time, I would like to thank our four speakers and all the participants for their involvement. But before you leave, there are two other things, and one is the announcement of the 8th and final webinar. And we're looking for speakers also for short presentations. I'll just share that with you. And after that, Laurent will introduce a very brief survey. We would like you to give your comments. So if I can go back to this. The final webinar, webinar 8, will be on the 12th of May from 3 to 4:30 Central European time. It will look at towards a broader and enhanced ENRIITC ILO and ICO network, and we're really looking for contributions from speakers, and that can be for flash presentations on your own experience of how we can use this network to more effect. So warmly recommended, and please advertise this fact within your networks and look for speakers for very short presentations so we can share experience on that. Then it remains just for me to give the floor to Laurent, who will introduce a very short survey.